In 1985, through the 52nd Constitutional Amendment Act, an anti-defection law was passed in India. Hi there, welcome back to my channel Educate with Milanjis. Today, let's discuss about this anti-defection law in detail. Before we go any further, if you had not subscribed my channel, please do subscribe my channel and hit the bell icon for getting the notifications of my upcoming videos too. Also, like the video if you feel that the content was good and comment in the comment section for any further clarification. So without any further waiting, let's move on to our topic. The 52nd Constitutional Amendment Act of 1985 provided for the disqualifications of the members of the Parliament as well as of the state legislatures on the ground of defection from one political party to another. For this purpose, it made changes in the 4 articles of the Constitution and added a new schedule, that is, the 10th schedule of the Constitution. This act is often referred to as the Anti-Defection Law. Later, the 91st Constitutional Amendment Act of 2003 made one change in the provisions of the 10th schedule. It omitted an exception provision, that is, disqualification on the grounds of defection not to apply in the case of a split in the political party. The 10th schedule contains the following provisions with respect to the disqualifications of the members of the Parliament as well as of the state legislatures on the grounds of defection. Number 1 is member of a political party. A member of a house belonging to any political party becomes disqualified for being a member of the house if he voluntarily gives up his membership of such political party, or if he votes or abstains from voting in such house contrary to any directions issued by his political party without obtaining prior permission of such party, and such act has not been condoned by the party within 15 days. The independent members. An independent member of a house becomes disqualified to remain as a member of the house if he joins any political party after any such election. Nominated members. A nominated member of a house becomes disqualified for being a member of that house if he joins any political party after the expiry of 6 months from the date on which he takes his seat in the house. This means that he may join any political party within 6 months of taking his seat in the house without inviting this disqualification. The above disqualifications on the grounds of defection does not apply in the following 2 cases. If a member goes out of his political party as a result of a merger of the political party with another political party. A merger takes place when 2/3 of the members of the political party have agreed to such merger. If a member, after being elected as the presiding officer of the house, voluntarily gives up the membership of his party or rejoins it after he ceases to hold that office. This exemption has been provided in the view of the dignity and impartiality of the office that he holds. Any question regarding the disqualification arising out of the defection is to be decided by the presiding officer of that particular house. Originally, the Act provided that the decision of the presiding officer is final and cannot be questioned in any court. However, in Quijotto-Holohan case in 1993, the Supreme Court declared that this provision as unconstitutional on the grounds that it seeks to take away the jurisdiction of the Supreme Court as well as that of the High Courts. It held that the presiding officer, while deciding a question under the 10th schedule, functions as a tribunal. Hence, his decision, like that of any other tribunal, is subject to judicial review on the grounds of malafide. The presiding officer of a house is empowered to make rules to give effect to the provisions of the 10th schedule. All such rules must be placed before the House for 30 days. The House may approve or modify or disapprove them. Further, he may direct that any willful contravention by any member of such rules may be dealt with in the same manner as a breach of privilege of the House. The 91st Constitutional Amendment Act of 2003 has made the following provisions to limit the size of the Council of Ministers, to debar defectors from holding public offices, and to strengthen the anti-defection law. The total number of ministers, including the Prime Minister in the Central Council of Ministers, shall not exceed 15% of the total strength of Lok Sabha. The total number of ministers, including the Chief Minister in the Council of Ministers in a state, shall not exceed 15% of the total strength of the Legislative Assembly of that state. But the number of ministers, including the Chief Minister in a state, shall not be less than 12. A member of either House of the Parliament or that of the state legislatures belonging to any political party who is disqualified on the grounds of defection shall also be disqualified to be appointed as a minister. A member of either House of the Parliament or either House of the state legislature belonging to any political party who is disqualified on the grounds of defection shall also be disqualified to hold any remunerative political post. The provision of the 10th schedule pertaining to the exemption from disqualification in the case of split by 1/3 members of the legislature party has been deleted. It means that the defectors have no more protection on the grounds of split. The following can be cited as the advantages of the anti-defection law in the country. It provides for greater stability in the political body by checking the propensity of the legislators to change political parties. It facilitates democratic realignment of political parties in the legislature by the way of merger of political parties. It reduces corruption at the political level as well as non-developmental expenditure incurred on irregular elections. It gives, for the first time, a clear-cut constitutional recognition to the existence of the political parties. Though the anti-defection law has been hailed as a bold step towards cleansing our political life and started as a new epoch in the political life of the country, but still it has been criticized on the following grounds. It does not make a differentiation between dissent and defection. That means it curbs the legislator's right to dissent and freedom of conscience. Its distinction between individual defection and group defection is irrational. In other words, it banned only retail defections and legalized wholesale defection. It does not provide for the expulsion of the legislator from his political party for his activities outside the legislature. Its discrimination between an independent member and a nominated member is illogical. Its vesting of decision-making authority in the presiding officer is criticized on two grounds. Firstly, he may not exercise this authority in an impartial and objective manner due to the political exigencies. Secondly, he lacks the legal knowledge and experience. Today, we had learned about the anti-defection law, the various provisions in the 10th schedule, the deciding authority, and the 91st constitutional amendment. I hope you all liked the video. Please do subscribe my channel and keep supporting me with your likes and comments. Till we meet with a new topic, auf Wiedersehen.